Hi everyone, welcome to Waterstone's weekly legal update number 3. You've caught us on a somewhat rainy day over in Rosedale and also on Casual Friday, so that's...
Welcome.
Welcome. We're going to be talking about the liquidation process. We get a lot of inquiries about how companies are liquidated, either from creditors who are owed money or from shareholders and directors that are facing financial problems. They ask us how does the process work, what happens, and what can they do about it. So we're going to run through a brief checklist on the process and what you can do, and also some legal changes coming into effect from the 1st of September that will affect how directors and shareholders are able to liquidate their own company. So William, why don't you just run us through some of the basics of the liquidation process, how it works, and sort of, you know, what steps are taken.
Sure. So one of the main, the instigators to a liquidation is going to be obviously insolvency. So usually there will be some financial troubles within the company, and that might come about from an invoice that's unpaid or a bill that's come through from the IRD for GST payments or PAYE or something like that from your staff wages. It could be a creditor who is applying to the court under another basis. And the first step in that process legally is the issuance of a statutory demand under the Companies Act, which basically is a formal demand for payment of an invoice or possibly a due debt.
And what we see a lot of is before the issuance of a statutory demand, there'll be requests for payment and following up and chasing, sort of emails and calls. It'll be a bit of history that goes with that stat demand. It's normally not out of the blue, but it's sort of a last resort. Once someone's gone through their own process in terms of trying to collect a due debt or a payable debt, they will issue a stat demand, normally through a lawyer or through the company itself. And there's a time frame or working day requirement that you meet that stat demand. It's about 15 working days that you must essentially pay it or apply to the court to set it aside. So if you can't pay the debt, what happens next?
So currently the process is that if a creditor applies to the court, then there is the option for the shareholders of the company or the board of the company to appoint their own liquidator once an application has been made to the court to liquidate and served on the company. There are a number of changes coming into company law.
That's the 10 working day rule, correct?
The 10 working day rule.
So after a petitioning creditor or parties applied to liquidate and they've served that on the company, right now you have 10 working days from that date to appoint your own liquidator, or for the shareholder to appoint their own liquidator, and that's going to change, like you just mentioned, with this new insolvency regulation practitioners bill.
Yes, so there is an act called the Insolvency Practitioners Regulation Amendments Act, which will come into force on 1 September, and that changes the rule, the 10 working day rule for the appointment of your own liquidator, and it says that the petitioning creditor must consent if a shareholder appointment of a liquidator or a board appointed liquidator is to be appointed.
So it essentially changes that current rule now, where you have 10 working days regardless of who applies. You have 10 working days to appoint your own, but under this new legislation, if it's a creditor winding up your company, you won't have the 10 working days essentially, you know, for free time to do that, and that essentially, if you want to appoint your own, the creditor that's petitioning, they'll have to consent before you can.
Yes.
So essentially, it takes the power out of your hands and gives it to that petitioning creditor.
That's right.
So what does that mean now for someone that is maybe facing a disputed debt, or they're going through a current process with a stat demand? What does it mean for them in terms of, you know, how they how they'll need to react. Does it change anything, do you think?
Yeah, I mean, Adam and I were discussing this earlier on today, and the most practical kind of advice that we came up with was that if you have been served with a stat demand, i.e. a formal legal demand for payment, and you have the foresight to know that the creditor is going to apply to liquidate your company, then really you have to appoint your own liquidator before being served with those proceedings, or else you lose the ability to appoint your own liquidator freehand, basically.
Sure.
You now have to get the consent of the petitioning creditor, and they might not agree with your choice, and there are a number of reasons, I suppose, why you might want to choose your own liquidator.
Well, I think as well, like if it's got to this stage, if somebody has been chasing a debt, they've issued a stat demand, that's run out. I mean, there's a history behind that, and they're not always on the best of terms in terms of that relationship. So, the creditor could be upset that they've had to go through the hassle and time and expense of applying to liquidate, because there's a bit of money involved in that. So they could be quite adamant that their choice of liquidator is appointed, and that the shareholders don't have their preferred option. Now, and you're just mentioning that there are some reasons why it's good or could be good to appoint your own liquidator. I mean, some of the things we're talking about was the fact that if you have the chance to meet beforehand with that particular insolvency practitioner, you have a familiarity. They know about your circumstance and about the business and what may have led to this point in time. So there could be a definite benefit for you in having that relationship beforehand, because you can essentially work more collaboratively. Whereas if you have a liquidator that's appointed by a creditor, there could be a more reactive or confrontational approach in terms of not having that familiarity beforehand. So there is some advantage there in having someone that and are comfortable with.
I suppose also it removes all of those prior tensions as well, between the creditor and possibly the company, because there's been that previous dispute. And like you said, if you've got the opportunity to, then you can explain a little bit about the history of the company and how it operates on a daily basis and stuff like that, and possibly what there might be some specific things that you want the liquidator to take into account when they come in and do their job. So there's definitely some advantages that can be gained from appointing your own
and
liquidator.
This is a big change. This removal of that
really
that
is.
10-day rule, because most liquidations happen sort of in terms of creditor application, in terms of court applications, are via creditors. So the IRD is a big one. They liquidate the vast majority through the courts. So this is a change that people need to make sure they're aware of and they know, because they don't want to get to the point of having been served and then the options taken out of their hands. So a much more proactive approach will need to be made during that process.
Yes, so effectively what needs to happen now is that once you have been served with a statutory demand, you have to have the foresight now as the director of the company or another person within the company to say, look, there is a new rule change and it says that we are going to lose the ability to appoint our own liquidator if we don't make some moves.
Well, big changes, and I think it's really important that if people are going through these disputes, that they reach out for advice. And at Waterstone, we offer 30-minute consultations, and they're bookable on our website. So if you have been issued with a statutory demand and you are looking at options in terms of how you deal with that, more than welcome to book an appointment with us and discuss options and potentially making that choice. So feel free to do so on our website and keep up to date with these changes, and we'll see you on our next weekly legal update. But thanks for watching, and
thank you so much.
Yeah, we'll see you next time.
Cheers.